of the
How much is the maintenance granted?
no, not at all granted. Dismissed for
Dismissed.
default.
Dismissed.
It
No, no.
is very
First of
relevant
all,
because they are
no.
misleading the court.
First of all, no, not about that. First of all, why is this when the court itself is dismissing the application for default?
Certainly, my lord.
Court should record the reasons.
Certainly, petitioner is misleading. They have urged the ground that the counsel passed away during the pendency. My lord,
When the court is dismissing, at least court should record. This is how it has happened. So many times he was not present, or she's not prosecuting the matter properly. Nothing. Morning call, evening
my
call,
lord, in
absent.
the order sheet, she has remained absent for 10 dates, my lord. It is in the very order sheet it is mentioned. The parties were directed to file assets and liabilities declaration. And for that, from 30/1/2021 to 23/12/22, they have not filed the assets and liabilities. That
Yes.
The petition, the petition, same is number 716/18 before it tried to put under section 125 of the
How much is the maintenance granted?
no, not at all granted. Dismissed for
Dismissed.
default.
Dismissed.
Dismissed for default.
Dismissed for you. Then you filed a restoration petition?
No, madam.
It's 125 CRPC. Where is that order?
Page number 20, madam.
Page number?
20.
Petitioner called absent, kept by for evidence. Petitioner and counsel called absent in spite of respondent having filed objections, address arguments on IA number 2. So for this reason, from 23/12/2022, this is here.
Yes, madam. My lord, what happened? During the pendency of the pandemic, she was unable to meet his counsel.
my lord,
And his counsel also explained.
my lord, I have one submission to make. The ground urged by the petitioner is that the counsel passed away. May I read, my lord? It is-
No.
my lord,
No, no.
it is very
First of
relevant
all,
because they are
no.
misleading the court.
First of all, no, not about that. First of all, why is this when the court itself is dismissing the application for default?
Certainly, my lord.
Court should record the reasons.
Certainly, my lord.
Let's forget about his reasons.
Certainly, my lord. My lord, but the ground urged before this court, the petitioner is misleading. They have urged the ground that the counsel passed away during the pendency. My lord, may I draw your lordship's attention? Page number 12. I'll just appraise that.
Why the
your
court
lordship.
is not looking at it is, even if you show,
Certainly,
it's
my lord,
not going
certainly.
to make any
But
difference.
my lord, the petitioner ought to have come to the court with clean hands. At page number 12, my lord, of the annexure A.
Yes.
My lord, it is at the bottom, the date is 28/1/2019, my lord. At the following page, my lord, page number 13, if I may read, my lord. First petitioner and respondent present, Shri PAR and Shri MAH advocates files wakalat for petitioners and respondent, respectively with IAs under section 13 of Family Court Act. No, my lord, erred on IAs and they are allowed. Petitioners and respondent are permitted to engage the service of counsel. Both parties are directed to appear before the Bangalore Mediation Center on 28/2/2019. Lord, the only ground urged here is that the counsel on record, Shri Seturaman Sabapati, passed away. But, my lord, he passed away on 18/1/2019. 28/1/2019, another advocate comes on record, my lord. Now that they have suppressed it before this court. That is all is my submission, my lord. I leave it to your discretion. I bow down.
Please come. No, when the court is dismissing, at least court should record. This is how it has happened. So many times he was not present, or she's not prosecuting the matter properly. Nothing. Morning call, evening
My
call,
lord,
absent.
in the order sheet, she has remained absent for 10 dates, my lord. It is in the very order sheet it is mentioned. The annexure A submitted by the petition.
Which cause will allow this?
I bow down to your lordship.
Agreed with the order passed with the court below, dated 23/12/2022, whereby the court had dismissed the petition filed by the wife seeking maintenance under section 125 of the CRPC. The petitioner wife is before this court. It is stated that the court, the dismiss the matter on 23/12/2022, observing that the respondent is present, petitioner called absent, kept by for evidence, case again called at 5 p.m. Petitioner and a counsel called absent. In spite of respondent having filed objections to IA number 2, petitioner had not opted to address arguments on IA number 2, and thereafter, in spite of scheduling the matter for evidence on 24/6/2022, not opted to lead evidence. Hence, petition is dismissed for default. Now, the present writ petition came to be filed stating that the advocate who was representing was no more. As such, the matter could not be represented, and hence the order may be set aside. Next para. Learned counsel appearing for the respondent husband submits that the petitioner has not come to this court with clean hands. In fact, the advocate who was pursuing the advocate died on 28/1 2019. Thereafter, they have engaged another advocate
On 28/1
on 28/1/2019, and such a fact, and they have come before this court with all misrepresentation of facts, and on that ground, this writ petition is also, as a writ petition also has to be dismissed. Next one. Having heard the learned counsels on either side, peruse the material on record. This court has perused the order passed by the court. The court, except stating that on a particular day, there was no representation. No, I'm looking at the order.
Yes, my lord.
Except stating that on a particular day, there was no representation, has not stated any valid reasons for dismissing the same. Learned counsel for the respondent submits that on 10 occasions earlier, the wife has not represented the
One submission.
matter.
Lord, as per Apex Court's order, Rajesh versus Neha, both the parties were directed to file assets and liabilities declaration. And for that, from 30/1/2021 to 23/12/22, they have not filed the assets and liabilities. That is also another reason why it was
It is
recorded in the
stated that
entire
as per
order.
the law laid down by the learned counsel further, it is stated that as per the law laid down by the Honorable Apex Court in Rajesh versus Neha, the wife had not filed hard statement of assets and liabilities. That's how the court below had dismissed rightly dismissed the petition. It's an application filed under 125 CRPC seeking maintenance. This court has recorded the contention of the learned counsel for the respondent and also perused the material on record. No doubt, there are lapses on the part of the on the part of the wife in pursuing the matter and pursuing a matter in the in doing substantial justice and in the interest of the parties. This court deems it appropriate to set aside the order dated 23/12/2022 on the condition that she shall pay an amount of ₹1,000 towards cost to the respondent. Accordingly disposed of. And the court, without granting any further adjournments, shall proceed with the matter.